to their websites. They wanted them to display in their websites either the principal employer or the contractors themselves as to the people who category of workmen who are being engaged, what are the wages being paid, and status records in the website. After representation from employers, this requirement has now been, for the moment at least, been kept on hold by the Delhi government. A few more banks have been notified by the Provident Fund. So if you have bank accounts with any of these banks, also the payments would be paid by the PF to these banks as well. Under the ESA Act, they're also going online and the portals are there. So employers are required to register employees within 10 days from date of appointment. Failing which, initially they had ensured that you were not even able to enroll employees, but then again they relaxed it. But if an employee is enrolled after 10 days of appointment, a show cause notice goes to employers on that, asking their replies. Now a circular has been said, please consider those explanation, and if any explanation is received within 7 days, to consider it, close it, and allow the employer to pay contribution for such employees, irrespective of the fact that the enrollment happened after 10 days. The ESI going more beneficiary friendly actions on the part of the ESI corporation. They want delivery of drugs and taking of home samples from the residents of the beneficiaries. In this regard, they have set out certain guidelines for their hospitals to follow. The quiz segment this month, it's a very simple question. An employee should have worked for a minimum of how many days to be entitled to bonus under the Payment of Bonus Act? Please do key in your answers into the chat box. We would touch on this, the reply for this at a little later. Across the globe, in United Kingdom, they have introduced an amendment to the existing Equality Act of 2010. This amendment comes into force from 26th October, wherein employers are required to take reasonable steps to prevent sexual harassment, and the various steps are there. And if an employer has failed to take the steps, then the government, the tribunal before which the issue goes, can award a compensation much more than actually what has already been provided under the Equality Act. So it is not about the complainant and the respondent here. It is more also about the employer having failed to give an environment or where he has taken proactive steps to ensure a sexual harassment free workplace. Germany has brought in laws. They are looking at bringing in more foreign nationals, even in unskilled works and skilled works, to their country because there's lack of skilled manpower. An interesting tidbit that we thought we'll share: in Austria, every employee worked for 6 months is entitled for annual paid vacation of up to 30 working days. And those who have ended 25 years of their entitled 36 working days of paid holiday in a year. This is a Madras High Court ruling. This is a peculiar case where the employees were not, they themselves were on, went on to pluck the leaves from the tea garden, sold them in the market and appropriate sale leaves. That was the case of the employer, and they said therefore for this period they did not pay any wages. However, the Provident Fund organization passed orders, around 11 orders, asking the employer to pay contribution for this period. The employer challenged it before the tribunal. And while challenging it, the prayer of the employer was that it should only be remanded back to the EPFO. But the tribunal, after considering the facts, felt that there were no wages being paid, hence a question of payment of contribution would not arise. And in fact, it came to the conclusion that the employees themselves were running the show by selling tea leaves, and therefore the question of the employer paying contribution for this period would not arise. And set aside all the 11 orders passed by the Employees Provident Fund organization. However, as the original prayer of the employer was only to remand back the case to the EPFO, the EPFO once again proceeded and was trying to recover the Section 7A proceedings. The Madras High Court held that the tribunal has set aside all the orders and therefore the EPFO cannot go on to make any recovery proceedings. So, but ultimately it has also given liberty to the EPFO, the organization, to challenge the order of the tribunal if they are agreed. This is a case where departmental inquiry was issued to two employees. One confessed of the misconduct and was imposed with the punishment of withholding of increment. The other did not confess. An inquiry was held and he was dismissed from service. He approached the Calcutta High Court. Ultimately, in writ appeal, the court observed that mild penalty was given to the other employee and tried to interfere. Matter ultimately went to the Supreme Court. The Supreme Court, more than the law of discrimination, it went into the aspect of the evidence that was there before it and found that there was a delay in initiation of the proceedings and that was not based on evidence, and hold the employee not to be guilty, and directed that the employee be reinstated. But more than that, the Supreme Court has also commented on the differential treatment in awarding punishment to the employees involved in the misconduct. In the past, there are judgments to show that an employee who's accepting his guilt can be treated differently from a person who doesn't accept the guilt but is found guilty at a later point of time. Here, but on the facts of the case, the Supreme Court has taken a different view. The answer to the quiz question is that you should have worked at least, an employee should have worked at least 30 days in a financial year to be entitled to bonus. It's not a calendar year, it's a financial year. In the POSH segment, we are looking at an interesting case of where an IRS officer and IAS officer are involved. So when there are two different departments, so Revenue Service and Administrative Service of the government, who should be conducting the inquiry? The internal committee of which department should conduct the inquiry was the moot question. The Delhi High Court held that the complainants committee was also entitled to conduct the inquiry and concluded that the inquiry had been done in a fair manner in terms of the POSH Act. The complaints calendar for the next coming month, we would also be sharing it with you. The knowledge corner for this month, we are looking at probationary employment. So what is this probationary employment is something, where does it flow from? As far as a person who would fall within the definition of workman, the classification under the Industrial Employment Standing Orders Act provides for probationary employment. Before I dwell more into the subject, you would need to be clear on the case laws and the laws on this aspect. When it comes to labor law, the Industrial Employment Standing Orders provides for it. Whereas service law, which governs government employees, is quite different. For instance, the period of probation could be up to 2 years in government service, whereas in private employment, it could be only between 6 to maximum of 12 months. And the laws are very different when it comes to service law and labor law on this subject. Therefore, when you look at any judgment, please have a look as to whether it is private employer, or is it under labor laws, or is it under service laws. So that's my premise on which I wish to start on this knowledge corner today. So a person, he could be engaged as a probationer more for the employer to see his suitability, and also for the employee to see whether the employer is suitable for him. On this question, therefore, whether he could be terminated, the Delhi High Court held that he is not a workman. During the probationary period, he could be terminated, and that would not amount to a retrenchment. Um, the probationary period, as I said, what could be the period? These are all case laws more under service law where they said that you have the right. But for instance, if the standing order says the maximum period of probation can be only 12 months, you cannot engage a person beyond the 12 months. You can maybe start even with 3 months or 6 months and keep extending it up to 12 months. But beyond 12 months period, you cannot engage any person as a probationer. So this probation period is more on a trial basis to understand what the employee is and what happens. There are certain, within the 6 months period or 9 months period, you could send the employee out as well. There are very, as I said, in service law, they have said it's not deemed confirmation, you don't automatically become permanent employees. But when it comes to labor law, it takes a different route. And so an employee on completion of the period could become, or rather would become, a permanent employee of the establishment. I'm not taking you through these case laws because we would be circulating the PPT, and you would be able to look into it. But there are many of these case laws which are in service law as well. So please be mindful when you look into these case laws. The last part of this knowledge corner on this topic is termination of probationers. So there have been cases where an employer issues a show cause notice to the probationer saying he's conducted a misconduct, he's committed a misconduct. And thereafter, they may just terminate him simpliciter. In such cases, the courts have gone to say that no, it is still a stigmatic because you had you had issued a show cause notice, so you did apprehend a misconduct, and therefore it cannot be strictly termed simpliciter termination. But if you're only going to say that the performance of the employee, in the sense your suitability for the employment, is alone considered and terminated, then it is a simpliciter. This is the distinctions that you need to be aware as to how this is one of the latest case of the Supreme Court when they have held that a probationer can be dismissed without notice during the probational period if he is found to be unsuitable for the job. So these are these aspects on which the legal issue has been considered by courts. So once a probationary period is over, it doesn't mean that in service law that he becomes a permanent employee. But if you look at labor law, he would start to get rights off a work. So therefore, please do be mindful on the period of probation. Kindly don't go by judgments that have been rendered under service law as far as this issue is concerned. With this, we come to the end of this month's presentation on labor laws. We hope to see you on 30th December 23 again. Thanks for joining. Have a nice evening.
Thank you, sir.